In this lesson, what I want to do is spend just a little bit of time talking about the concept of omissions in relation to the tort of negligence. So we're just going to explain what an omission is. We'll explain the general rationale, the sort of general approach that is applied for the tort of negligence in relation to omissions, and then we'll examine a couple of cases which illustrate this point in a bit more detail, essentially. So this lesson and the next is going to talk about the concept of the liability that arises out of an omission rather than specifically an act. So this is not just a single lesson that we're going to focus on the concept of omissions. We'll talk about the general approach in this lesson, and then we'll talk about liability for omissions in the next. So ultimately, the first question that I would probably want to ask you is, what is an omission? Well, if you are somebody who has studied the criminal law, you will have an understanding of what an omission is already. But an omission, as the name suggests, is simply a failure to perform a particular act in a particular circumstance. Okay? So, whereas in previous lessons where we've been talking about the tort of negligence, we've been talking about it from a very act-centric approach, an act-centric suggestion, i.e. somebody is doing something in a way that essentially gives rise to negligence by way of a breach of some kind of duty of care. What about if they just fail to perform an action which would give rise to a duty of care? How does this actually operate? So rather than talking about negligence being caused by an act, we're talking about failure to perform an act which gives rise to negligence. Now, the general approach in all of law is that the failure to do something, the lack of performance of an act in a general setting does not give rise to liability. And this is the general approach which is applied in English law, and specifically within English law in relation to negligence as well. So there is no duty of care owed to an individual to prevent someone else from injuring themselves. Okay? And so as a result of which, because there is no duty of care owed to an individual to prevent them from injuring themselves, a failure to do so would not give rise to a breach of duty. And so as a result of which, there cannot be a claim in negligence for omissions. This is the general approach, and of course there are exceptions which we're going to get to, hence why there is a whole lesson, 2 lessons on this question. But when it comes to the sort of general rationale for this approach, why is this the case? Why is it the case that this is how the English law is established? Well, the first of these reasons is relating to this idea of policy implications. A lot of the tort of negligence, a lot of other torts, are structured in a way that give a lot of consideration to the policy implications. Okay, one of the things that judges and courts and litigants are very scared of is this idea of quote unquote floodgates, a floodgates of new litigation as a result of as a result of a ruling which could give rise to a potentially infinite number of claimants. So policy implications is very important, and it is a very important rationale for limiting liability when it comes to omissions. There is a potentially infinite number of things a person could potentially do to help prevent the harm of another individual. You could go out and walk around in the street, and you could do many, 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 many things which could prevent somebody else from being harmed. Okay? And if this was not the general approach, failing to do any of those things could give rise to liability. So everybody should potentially have to live in fear of being sued for failing to perform an action which could give rise to liability. There's also a burdensome rationale. This idea of tying to the previous point, it would create an incredibly heavy burden to be placed on a defendant who might just be a general passerby and might not have the relevant and prerequisite foresight to actually know if that person in question is going to be injured, and then therefore, as a result, you should act in a particular way to prevent that injury. All of these things sort of goes against the sort of general process by which time operates, and it also increasingly leaves a ridiculously heavy burden onto a defendant. You could leave and go to the shops, and there could be, like I've said in the first point, a potentially infinite number of things that you could do to prevent people from being harmed in many different ways. That would mean that you could be potentially sued by just going out to the shops every single day, etc., etc., etc. This is a part of the rationale. Finally, there's this idea that there is a certain amount of indeterminacy regarding the application of a duty of care and the identification of good claims. Because one of the things that is interesting when it comes to omissions is that a failure to act is not so easy to essentially establish a chain of causation than a clear act itself that was that would satisfy things like the but-for test when we talk about causation. So this idea of there being indeterminacy means that it is difficult to identify good claims. And so these are all the reasons why, generally speaking, the failure to perform an action which could have prevented someone from being harmed, it is not a rationale for being able to essentially give rise to liability. It is only in the exceptional circumstances where it is very clear that an omission could lead to liability that we see an omission actually give rise to said liability. So let's talk about a couple of examples from case law that illustrates this. The case of Stoven and Wise from 1996 is a good example. In this case, the local authority had left some obstruction on a busy road. Okay, so that's essentially the long and short of it in terms of the setting the scene, if you will. The result would be that the obstruction would essentially cause a car accident, and this obviously could give rise to liability in this case. Was the local authority liable in negligence for their failure to remove the obstruction and therefore to not prevent the crash? That is the question that that the courts were asking here. It wasn't an act that the local authority had done. They hadn't done something. They had failed to do something. They had failed to remove this obstruction, which then led to a car accident. It was held that there was no liability, since the decision not to remove the obstruction was just part of the general discretion of the local authority. It wasn't really a failure to act. It wasn't really something that they should have done or had to have done. It was just generally part of their discretion as a local authority to just leave this obstruction visible and in the way, essentially. So it was less a failure to act and just more the sort of general state of affairs that had existed within this local authority. Moving on then, in 1987 we get the case of Smith and Littlewoods. The case of Smith and Littlewoods is one which involves the owner of a disused cinema. Unknown to the defendant, occasionally people would go and stay in this cinema for periods of time, and they would often do so by sort of essentially squatting in this cinema. And when they did so, they would lay fires there as a result. One day, an attempt to light said fire would cause damage to a number of other properties that were in and around the area. So essentially the fire got out of control, it got out of hand, and it caused some damage to some other properties that were next to the cinema. The owners of those properties decided that they should sue the owner of the disused cinema, not for their act, because they weren't the ones who lit the fire, but for their failure to allow their omission in allowing the situation to cause damage to their property, their failure to essentially secure their cinema in such a way as to ensure that people weren't going to squat there and light fires. Again, it was held that there was no liability on the part of the defendant, and the House of Lords suggested that there was no duty of care, and therefore no lack of a breach of duty of care. If there was no duty of care, then there can't be any claim in negligence. And so that's essentially the two cases which illustrate the general rule for the concept of omissions. Like I said, the next lesson is going to talk about situations where liability can arise out of omissions in the tort of negligence.